What happens when a defendant violates a no-contact order while still in jail? Today's case features one of the most awkward moments we've ever seen. A defense attorney finding out in real time that his client completely sabotaged his own case. Michael Jones Fuller was ordered not to contact his victim, but jail calls reveal he did something incredibly stupid. Watch as his attorney goes from confidently defending him to literally yelling at him in open court. The judge's reaction? Let's just say that $25,000 bond is about to get a major upgrade. This is why lawyers tell you to shut up when you're in jail.
Good morning, Your Honor. Marcia Creature on behalf of Mr. Jones Fuller, who is hearing. Can you please state your name, sir?
Michael Jones Fuller.
Good morning, Your Honor. Your Honor, we'll be requesting a preliminary exam in this matter, Your Honor.
All discovery is complete.
Yes, Your Honor. I've received the complaint. I've received body cam video and the police report, Your Honor.
I do have one thing about bond I'd like to bring to the court, Judge.
Before I said it or after?
I'm sorry, whenever the court.
Okay, well, I'll do it this way. Would the people's witnesses be available the second?
I will try my best, Your Honor.
Preliminary examination in person, July 2nd, 2024, 9 a.m. That is before Judge Perry. Yes, that's the bound.
There's a strangulation case in a DB third. When he was arraigned on June 13th, 2020, he called his friend, after he was told not to contact the victim, he called his friend to ask and gave the friend the victim's phone number and asked the friend to have the victim bond him out or to give him money to bond him out.
Stop right there. The prosecutor just dropped a bomb. Let me explain why this is so damaging. When you're arrested, the judge typically issues a no-contact order, meaning you cannot contact a victim. Not directly, not through friends, not through carrier pigeons, nothing. But Mr. Fuller thought he found a loophole. He called a friend, gave him the victim's phone number, and asked him to get money from the victim to bond him out. That's not just a violation. That's witness tampering and potential intimidation. The audacity of asking your victim to pay for your freedom is mind-blowing. And the fact that he did this right after being told not to, that shows complete disregard for court orders. Watch how his attorney reacts. This is about to get messy.
So I'm concerned about the fact that he was ordered by the court not to contact the victim, and then he went ahead and did that prior to being bonded out on the 13th jail call. We had originally asked for a $250,000 bond in this case, and he was given only a $25,000 bond. So I am concerned about that.
But
Yes.
Mr. Creature.
Madam Prosecutor said she sent me, and I'm sure she did, but I've not received the audio of the jail call, so I cannot respond what's in it, what's not in it. What I can tell the court is that
There were calls made to the victim.
I can't represent
Correctly.
that. I haven't heard them. I
guess I want to make sure I'm hearing what think I'm hearing.
There were calls made to third party, telling the third party to contact the victim and giving the victim phone number to the third party. That was the same phone number in the police report.
Got it. Okay. Go ahead.
All right, so I cannot speak to the phone call because I've not heard the recording of it. What I can tell you is that I have yelled at my client, admonished my client if that did happen, he's not to have any contact with the victim. He's not to contact or have a third party contact her in any way or fashion.
This is painful to watch. The defense attorney is in an impossible position. He's hearing about this violation for the first time in open court. Notice how he's trying to dance around it. I haven't heard the recording. If that did happen, classic lawyer speak when you're blindsided. But then he admits he's already yelled at and admonished his client, which suggests he knows something went down. The prosecutor originally wanted $250,000 bond, but got knocked down to $25,000. Now that decision is looking pretty questionable. The judge is about to ask the critical question that's going to force his attorney to get the truth from his client right now. This is every defense attorney's nightmare. Finding out your client lied to you in front of a judge.
Passion.
Well, why did he do that in the first place?
I don't know if he did or he didn't. It's the
Mr.
first I've heard of
Allen.
it.
Go ahead, what?
He explained to me that he did make a call to his friend Ali to have funds released so he could be bonded out. That's what my client tells me. I don't have the jail
So
costs.
he's saying that he didn't have any contact with or direct anybody to have contact with the victim in this case? Is that what you're representing to the court?
If I could have a moment, Your Honor.
Yeah.
I'm sorry. Did you tell him to call the witness? Did you say that? Did you say that? So you did do that? Yes. Okay. Your Honor, after conversations with my client, he states to me that he did ask his friend to contact the complaining witness.
Oh my God. Did you catch that dramatic moment? The attorney just had to turn to his client mid-hearing and basically say, "Did you do this?" And Fuller admitted it. This is courtroom gold. The defense attorney went from, "I don't know if he did it," to, "Okay, he definitely did it in about 30 seconds. You can hear the frustration in his voice. This is why attorneys tell clients to be 100% honest, because surprises like this destroy your credibility with the judge. The attorney is now scrambling to do damage control, but the damage is done. Fuller just proved he can't follow simple court orders even when he's locked up. How do you think the judge is going to react to this blatant violation?
In order to release funds to have him bonded out, Your Honor. He understands that he shouldn't have done that. I've yelled at him about that. I've explained to him that he cannot have any contact with the victim. He did not, on that jail call, from listening to Miss Blanche's details, tell her not to show up, tell her not to cooperate. So I would ask that he be allowed to remain out on bond, Your Honor. I hear you. I can't hear you. Sure. And he wanted me to continue to say that he is fully employed, has a job waiting for
I
him.
understand that, but he's given certain conditions regarding his bond and just willfully violates. Defendant's bond is modified. Defendant's remanded. Defendant's bond will be set in the amount of $100,000 cash share.
Thank you, Your Honor.
Boom. The judge just quadrupled the bond from $25,000 to $100,000 cash. And notice, it's not just the amount that changed. The defendant is remanded, meaning he's going straight back to jail. The defense attorney's last-ditch effort to save his client by mentioning he has a job waiting, the judge shut that down hard. I understand that, but he was given certain conditions and just willfully violates them. That's judge speak for your client is an idiot who can't follow basic instructions. This is a textbook example of how one stupid jail call can cost you your freedom and $75,000 extra in bond. The lesson? When a judge tells you not to contact someone, that means no contact through anyone. VO 6, final summary in CTA, after 5:05. Let's recap this courtroom disaster. Michael Jones Fuller was out on a $25,000 bond with one simple rule. Don't contact a victim. Instead, he called a friend from jail, gave him the victim's phone number, and asked him to get money from the victim for his bond. His own attorney didn't know about it until the prosecutor revealed it in court, leading to one of the most awkward attorney-client conversations we've ever witnessed. The result? Bond increased to $100,000 cash and immediate jail time. This case perfectly shows why defendants should always listen to court orders and be honest with their attorneys. One phone call cost this man his freedom and possibly his job. If this courtroom catastrophe shocked you, smash that like button and comment below. What's the dumbest thing you've seen someone do to violate their bond? Don't forget to subscribe and ring that bell for more jaw-dropping legal fails every week. Let's recap this courtroom disaster. Michael Jones Fuller was out on a $25,000 bond with one simple rule: don't contact the victim. Instead, he called a friend from jail, gave him the victim's phone number, and asked him to get money from the victim for his bond. His own attorney didn't know about it until the prosecutor revealed it in court, leading to one of the most awkward attorney-client conversations we've ever witnessed. The result? Bond increased to $100,000 cash and immediate jail time. This case perfectly shows why defendants should always listen to court orders and be honest with their attorneys. One phone call cost this man his freedom and possibly his job. If this courtroom catastrophe shocked you, smash that like button and comment below. What's the dumbest thing you've seen someone do to violate their bond? Don't forget to subscribe and ring that bell for more jaw-dropping legal fails every week.